So, what are rulemaking appeals to the governor's office? When and why does a regulatory agency appeal certain decisions to the California governor's office? Now, while the last time this occurred was around 2007, a state agency does have the authority to appeal the rejection of a regulation, that rejection being made by the Office of Administrative Law, OAL. Now, OAL is required when it reviews a regulatory filing to either approve a regulation that's submitted to it for review and therefore or thereby transmit it to the Secretary of State for filing. The other option, of course, is to disapprove it. And either way, it has to occur within 30 working days after the regulation has been submitted to the OAL. Now, if the Office of Administrative Law disapproves a regulation, then OAL is required to return that regulation to the adopting agency, again within that 30-day period, accompanied by a notice specifying the reason or reasons for OAL disapproving the regulatory action. A regulation cannot be disapproved by OAL unless the regulation failed to comply with one or more of the six statutory standards of review or some other provision of the APA. OAL's decision to reject can, in fact, be reviewed. First, the adopting agency is required to file a written request for review with the governor's legal affairs secretary, and that filing with the governor's office has to be made within 10 days of receipt of that written opinion provided by the OAL, which is the reason for the rejection of the rulemaking. The request for review by the governor's office has to include a complete statement, along with a number of other specified materials, regarding why the adopting agency believes the decision by OAL was incorrect and should be overruled. Second, OAL is then going to file its written response with the governor's office. Specifically, OAL must file its written response to the adopting agency's request for the governor's legal affairs secretary within 10 days and deliver a copy of its response to the adopting agency on the same day that OAL delivers its response to the governor's office. Now, thereafter, the governor's office is required to provide the requesting agency and OAL with its written decision within 15 days of receipt of the response by OAL to that agency's request for review by the governor's office. Now, finally, if the governor does overrule OAL's decision to reject that rulemaking, then OAL must immediately transmit the adopted regulation to the Secretary of State for filing, and then the governor is required to immediately transmit to the committees on rules of both the state assembly and the state senate in the California legislature. And the governor's transmission has to include a statement of the governor's reason or reasons for overruling this decision by the Office of Administrative Law. So that's how a regulatory agency can appeal to the governor's office due to an OAL rejection of its regulation.